Can a debt collector garnish my bank account? Hi, this is consumer protection attorney Bill Clanton. I've helped hundreds of people, consumers, deal with debt collection harassment, inaccurate credit reporting, and other consumer-related matters. In this video, I'll answer the question, can a debt collector garnish my bank account? Well, the short answer is yes. The longer answer is yes, but. Okay, so a debt collector cannot say you owe money and I'm going to garnish your bank account, at least not in Texas. So under Texas law, a debt collector will have to get a judgment against you. That means they'll have to file a lawsuit against you. Generally, they hire a lawyer. Many debt buyers have lawyers on staff. Some debt collectors have lawyers on staff, and they will file lawsuits. There was about 500,000 of these lawsuits filed, maybe 300,000. I forget the exact number. It's in another video, but last year, in 2020, there was hundreds of thousands of these lawsuits filed. So they file the lawsuit, they get a judgment. Now, something like 90% of these cases go to a default judgment. That means you, the consumer, the person who's sued, doesn't answer, which is a big mistake. I talk about that in another video. Now, when you don't answer, they get a default judgment against you. When they get a default judgment against you, or any kind of judgment against you, then they can use that to garnish your bank account. They file a garnishment action, a separate lawsuit in the same court for a writ of garnishment. And with that writ of garnishment, they can freeze your bank account, and after the court gets an order, they can empty your bank account. So, yes, a debt collector can garnish your bank account, but they have to follow all the proper steps. And often they make mistakes in those steps. Sometimes they don't file the correct evidence they need. Sometimes their garnishment pleadings are incorrect. And if you file an answer further up the chain of events here, if you get served with a lawsuit and you don't ignore it and you file an answer, you can defend yourself in this lawsuit or settle this lawsuit and keep it from ever getting to the judgment stage. So yes, a debt collector can garnish your bank account, but they have to do it with a judgment, and they have to then file a garnishment action. Another way that debt collectors can seize money in your bank account, it's not technically called a garnishment, it's called a receivership. They have to get a judgment, and then they can get a receiver appointed, and that receiver can send a letter to the bank. It's the same effect to you as a garnishment, but the legal steps behind it are a little bit different. And so a receiver can freeze your bank account and take your money out. And that's become more popular with the debt collectors since the law changed in 2017. So the answer is yes, a debt collector can garnish your bank account, but they have to take the proper steps, and they have to have a judgment before they can do anything like that. I hope you liked this video. Well, I don't know if you like hearing about garnishment, but I hope you got something out of this video. And I'd appreciate if you would subscribe to my channel. Thank you for watching.